Haven't we seen you before?
Vaguely, yes.
He's a repeater.
I'm sorry?
You're a repeater.
I'm a second offender.
We're going to habitualize you now.
Yes. Many people have habitualized me already. You're not the first.
All right.
May it please the court, Ron Letterman on behalf of the defendant appellant. I'd like to reserve 2 minutes for rebuttal, and I willingly waive the 2-minute bullet-free zone. Please feel free to
I like how you elevated it from free fire to bullet free.
Okay.
I like it. All right, I'm going with it.
This case presents an interpretation of EPIC, and within EPIC, the patient advocacy designation statutes. It presents issues of whether or not a jury in a circuit court tort action may, after the fact, essentially Monday morning quarterback what should be decisions of the probate court or which should be parts of procedures under EPIC and circumvent those procedures. It is our position that the trial court properly granted summary disposition in favor of the nursing home when it acquiesced to the statutory procedures for determining whether or not it was necessary for it to discharge the patient upon the patient's request after the revocation of the patient advocate designation. To determine the proper scope of liability here, I think that there are two different points of time that have to be set forth. The first would be the pre-revocation of the designation.
That's October to November.
Yes, until November 15th. And at that period of time, the nursing home was bound under statute to adhere to the dictates of the patient advocate whose status was activated upon the certification of two doctors that the patient was unable to participate in her medical decisions.
I don't think anybody's, does anybody dispute that period now?
Well, my interpretation of the Court of Appeals decision.
Here, do you think anybody's still disputing the entitlement of the nursing home to rely on the PAD for that October, November?
Are you asking with respect to the panel? Is anyone in the panel?
No. I thought, does the estate contest the validity of relying on the PAD during that period?
I guess I would let the estate answer that question directly. I presume that it does, because the estate seems to take the position that the circuit court jury had the ability to determine whether or not the patient had the ability to participate in medical decisions.
But counsel, good morning. I guess the
I'm sorry?
no problem. The question is, didn't the legislature make it so that you could withdraw your patient advocacy designation relatively easily? And isn't it designed to do kind of what it did in this case?
Yes, the patient advocate designation could be revoked, notwithstanding the fact that the patient
Might be incompetent.
Well,
that then brings us to the real exquisite part of the case. I have a lot of sympathy for the nursing home that has what it believes an incompetent patient who is now at least attempted to withdraw the former approved PAD. But what right do you have to continue to hold her if she says after that revocation, I want out of this place? It's against doctors' orders,
yes,
advice. I understand all of that. But what, under EPIC, it appears that she has the right to do that.
Well, the nursing home still has the obligation to act.
It's a perfect catch-22 for I concede all of that. But as a matter of legal position, I guess you have the argument that she did not have the competence after the revocation, but isn't that a question of fact?
No, it's a question to be resolved by the probate court upon the filing of a petition for guardianship.
So even though the legislature has said that she can revoke it anytime she wants, you say we get to say if she revokes it and we are suspicious of her mental competency, she then has to go to probate court, even though the statute doesn't say you can revoke it, but if we have any questions about it, you have to go to probate court to, like...
The statute, a different part of the statute, 5503, says that any party with interest...
Your client is not one of those.
I'm sorry?
Your client isn't a party in interest under EPIC,
But the
are you?
patient is, right?
We are not a party to contest the revocation. We are a party, however, to file a petition.
Did your client file a petition then?
We did not file a petition. What we did, here's what happened. What we did was we told the patient advocate and we told the family that we cannot contest the revocation, but that we have problems because there's 2 doctors on file who have certified the patient to be incapable of making the medical decision.
So that might be true, but I thought you just said that your remedy in that circumstance is to go to probate court and file for the guardianship, which you didn't do.
We didn't do that because immediately upon issuing the revocation, the family filed a petition for habeas corpus in circuit court to determine the legality of the confinement. Okay. We filed a response, as we were permitted to do, and we said to the circuit court, we don't think this is the appropriate vehicle for this determination, but we are looking for judicial guidance because we don't know who we're supposed to listen to.
Well, but wouldn't it have been better to not only file a response in the circuit court, but also to file an affirmative petition for guardianship in the probate court?
Just like photocopy it and file it in both places?
The patient advocate did that.
Okay.
And so it was done. It didn't have to be done twice. The patient advocate did that.
But once the patient advocate did that, why do you think that the status quo doesn't change? Like ordinarily, if you want to alter the status quo or preserve the status quo, you would file in court and then you would file for like a temporary restraining order or
correct. That was not done.
Yeah,
that was not done. Frankly, there was no time. The 15th came, the revocation came, the petition was filed immediately for habeas corpus. We went before the court on the 16th. The following day, the court knew that we were waiting for a judicial decision as to what to do, as to who to listen to, and the court said, I think that the probate court ought to make this decision. Inherent in that, now yes, the order did not say maintain the status quo. It did not say that. I admit that. But inherent in the order which says that the probate court should resolve all of your concerns, that means maintain the status quo so the probate court could act promptly.
Maybe, sir, maybe you went on the merits, but it strikes me that the propriety, the legal authority of the nursing home to retain her after she made the revocation, because she did sign something, correct?
She signed the revocation.
And said, I wanted to leave.
Correct.
All right. As I understand EPIC, the question then is, was she competent at that point?
Did she have informed consent? Was she competent? Yes.
And as far as I can recall, the nursing home, although there are 2 doctors who certified the appropriateness of needing a PAD initially, they didn't, subsequent to her revocation, say she remains incompetent, did they?
No, because the plaintiff did not file the appropriate petition for those doctors to do so.
Well, but the only basis for you legally to retain her after she's attempted to revoke is that she remains unable to participate in her decision-making.
And under our duties under the Patient's Bill of Rights to always act for the patient's best interests. If we would...
Except EPIC makes it possible for her to act outside of her best interest. And that's why I'm wondering why you would resist so strenuously in suggesting that there aren't questions of fact regarding your client's legal authority to retain the decedent
Because the law,
after she revoked.
because the law still permits an interested party in a case like this to file a petition for guardianship.
But there is no, you have no legal authority. You can invoke the judicial process. You didn't do it, somebody else did, and you never got a restraining order saying we're going to maintain the status quo.
I admit that the order of the circuit court on the 16th did not affirmatively state, let's maintain the status quo. But it was
Isn't that a problem for your client, then?
I think that the language that was in the order was sufficient to allow an interpretation that the status quo ought to be maintained while the probate court was going to immediately determine the guardianship issue.
But counsel, didn't she communicate her wishes?
She communicated her wishes, and if there was no issue regarding her competency, then her wishes would be adhered to.
But isn't that really the way in which this was drafted, was to allow for people to enter into a patient advocacy designation circumstance because they know that if there's even a question of their ability to communicate, that their wishes would be followed?
Yes, except for the fact that there is also a procedure set forth in the statutes for the immediate filing of a petition for guardianship when it's clear that the party who is duty-bound to act in the best interests of the patient has a question.
Okay, so what's the takeaway, though? So, I mean, because this is such a critical issue for people who are trying to make these decisions for themselves, for their family members. What is the takeaway? What would your argument be? If I enter into a patient advocacy designation situation where I'm going to let someone else make healthcare decisions for myself, what's the takeaway? What do I have to be thinking about? What do I have to be conscious of? What do I have to be cognizant of as it pertains to my ability to revoke that patient advocacy designation?
You have to be cognizant of the fact that, yes, you may revoke. However, if you do not simultaneously grant a successor patient advocate and you happen to be mentally incompetent, then there's going to be problems and confusion with respect to who has the ability to speak on your behalf. And that's why the statute also contains the provision that allows an interested party, such as a nursing home or the patient advocate, to go to the probate court for guidance.
I am extremely sympathetic to the catch-22 that the nursing home found itself in with somebody, a patient who the nursing home thought was incompetent, but who's revoked the advance directive. But given that the apparent theme of EPIC is to provide maximal self-direction to the patient, that's why there's an asymmetry. You have to be competent to enter into the advance directive, but you don't have to be competent to withdraw it. That's the asymmetry we're dealing with here. And unfortunately, after she's withdrawn it, I don't see how your client, maybe all that happened here will show that she wasn't incompetent and therefore your client was appropriately keeping her, but I don't know how we can say that. There is no court order that says you had the right to keep her, and it seems to me somebody is going to have to figure out whether the facts support your client's continued retention or not. It looks like a fact question. In the absence of an order saying your client could do what it did, what is our leeway?
I think that you do have the order.
That's not a restraint. It's not a.
I understand that that the magical language that.
That's not magic. Magic is not required here. All it's required is saying you may continue the status quo. That was not here.
And there wasn't any motion on your behalf. I mean, you didn't file any motion saying, Your Honor, please rule that the status quo ought to be maintained, right?
That was in,
Like,
no, we filed our immediate response to the petition for habeas corpus. We indicated directly that we don't know what to do. We don't know who to listen to. We don't know if the patient is mentally competent to speak for herself.
And the circuit court didn't help you.
The circuit court said,
somebody else should decide
the
that.
circuit court says, yes, I understand. I'm going to let the probate court decide this.
At that point, your client is still at risk. And that's why you're here today.
And then that's why the client continued to rely upon judicial guidance.
No, there was no judicial guidance.
The
That's the
judicial-
problem.
The judicial guidance was received by the probate court 5 days later when it said that there's no basis to appoint a guardian. And at that point, we discharged the patient against medical advice.
Okay.
Had we discharged the patient, as you say that we had perhaps an obligation to do, and it turned out that the patient was indeed mentally incompetent, and it turned out she goes home and finds herself into harm's way, we're exposed at that point because we didn't necessarily act in the patient's best interest. So there's a catch-22 there.
I see that.
And by providing the statutory remedy of a guardianship and allowing us and the patient advocate to file a petition to make that, for the probate court to make that determination, inherent in that right is the fact that we are allowed to maintain the status quo, because if we give up the status quo, it becomes moot. How do you file a petition for guardianship? How does that petition continue to be viable if you are forced to give up
Because
the
you
patient?
asked the court explicitly for the authority to maintain the status quo. You're out of time. Thank you.
Thank you.
Good morning, Mr. Chief Justice, and may it please the Court. Matthew Nelson on behalf of Ms. Hardy, the personal representative of the estate of Ms. Roush. The legislature has repeatedly demonstrated that the liberty interests of a patient, what Mr. Chief Justice, you referred to, the right of maximum self-direction, that liberty interest to make the medical decisions for herself overrides institutional convenience for institutions like Laurels. And this can be seen in Section 55092, where the legislature automatically suspends the patient advocate's authority when the patient regains the ability to engage in her own medical decision-making. This concern is also demonstrated in 5510D, where the legislature has set an extremely low bar for revoking the patient advocate designation. And it's seen in the Patient's Bill of Rights, in the Public Health Code, where a nursing home patient has the right to discharge herself from a nursing home. The patient advocate designation provisions in EPIC do not provide institutions with blanket immunity. Instead, those provisions provide the opportunity for judicial review. But the burden should never be on the patient to go to court to get her freedom. It seems that the court understands the issue after the revocation. So I'd like to, at least for the time being, focus on the period before the revocation. And I believe that 55092 addresses why that remains at issue here in this case. Under Section 55092, if the patient regains the ability to participate in medical decision-making.
You are contesting that first period.
We are contesting the first period.
What's the
Did
basis?
you divide it, is there something about like October 24th and then November 8th? I feel like there are two pre-revocation periods.
So in our complaint, we said the false imprisonment started around November 8th.
Right.
When she first indicated. The Court of Appeals, and the Court of Appeals decision says there's a question of fact with regard to whether or not she was in fact capable of making her medical decisions when the doctor said she was not.
Do you contest that at all, or can we write out October 24th to November 8th?
Your Honor, I think frankly what this court ought to do is deny the application and just remand it because there are so
All
many
right.
factual issues. But
Engage us for the plural.
Right,
You're here, so you drove all the way over from Grand Rapids, so just.
Right, so I came out, let's discuss that. With regard to that period of time, the issue is, we just haven't had sufficient discovery to be able to make the determination.
Wait a minute. What is the basis for challenging the efficacy of the PAD at least until November 8th?
That it was activated. Do you concede there's no genuine factual issue as to the activation of the?
It was activated. The only issue that I can see, Your Honor, would be the question of whether it was appropriately activated or not. What was the judgment of the doctors at the time? What were the facts that were under consideration? And I'm not sure.
Let me just ask, just stepping back from this case, if, and I think the procedure is the patient signs it, and then at some point 2 doctors say, Bob's lost his marbles, it then gets activated, correct?
Yes, Your Honor, that is the process.
All right, so you think that the patient can file a suit challenging the 2 doctors' medical judgment?
Yes, Your Honor. Let's take, for example, a patient who is brought into the institution by a family member. The patient is reading law review articles and accurately completing the crossword puzzle from the New York Times. And the 2 doctors say...
But I think I'm Teddy Roosevelt.
No.
I can read, but I'm...
I think his point is you think you're Bob Young.
Oh, okay.
Yes.
Then I'm okay then.
You think you're Chief Justice
All right, go
Young.
ahead.
You've been brought in, but your family member says he's lost his mind.
Because they're tired of you, which is.
Well, that's
not
true.
unimaginable.
Thank God I can still sign myself out. Go ahead.
Well, you can sign yourself out unless the 2 doctors say, we agree, and contrary to all the evidence. And that's the only issue that I can foresee with regard to.
So this is a collateral attack. You're essentially collaterally attacking the medical determination of incompetency that initiated the PAD.
We're
Correct.
attacking it.
It's not being a court order, but yes, we're potentially attacking that decision. I don't know the factual record hasn't been developed sufficiently to determine this. This is why we say there's still a factual dispute here. Whether after discovery closes there will continue to be one, that I'm not sure of. But with regard to, and let me clarify one other thing. I'm not sure, we've been using the capacity to make medical decisions and competency somewhat interchangeably. I'm not sure that they're interchangeable. Competency is a determination that's made by a court, subject to various guidelines. This has no guidelines whatsoever in the statute. With regard to the period between November 8th...
I have a question, though. What do you do with lucidity, and what if it comes and goes? Like, what if you have a person who's competent, then they're not competent, then they become competent? What are you supposed to do if you're a nursing home in that situation?
Well, I think you're supposed to do exactly what every medical provider is supposed to do in that situation. During those periods when the person is competent, you are to take direction from them because that's their liberty interest in making their own medical determinations. When they do not have that ability, then the patient advocate designation is in effect. And I believe that's clearly what's set forth in 55092, which is to say that the patient advocate's authority is suspended during those times where the patient regains the ability to make medical decisions.
But if they make a decision and they're lucid and then they're not lucid, if they're lucid for just a short period of time, you're saying that that would be sufficient?
I would say that would be sufficient. And in fact, if you think about it, I think this is exactly what the legislature wants in terms of if I'm coming in and out of consciousness, and during the times that I'm conscious, the doctors talk to me and find out what my wishes are, that's precisely what we want. And I realize that can potentially put healthcare providers in a difficult situation, but I would submit that in most instances, there's a reason we don't see many of these cases. This sort of thing doesn't happen very often.
Well, we might see more if we have an opinion on this case.
Your Honor, well, in that case, again, I would say deny the application for leave, and we can see whether this issue actually develops. But With regard to that, I think the legislature's made very clear the liberty interest of the patient has to trump the administrative
I think I
convenience.
understand that. Help me understand the period after the 15th where the revocation is quite evident. It seems to me that even an incompetent person can revoke the PAD, correct?
Yes, Your Honor.
Then the question, it seems to me, is who gets to determine whether her expressed wishes are honored or not?
Yes, Your Honor.
In the instance where the nursing home believes she remains incompetent, what must they do to insulate themselves from liability, either for discharging her when she's incompetent to make that decision and against medical advice, or respecting her wishes if she's capable?
Well, Your Honor, I think that the answer there is provided by the statute, which says you go to court not to petition for guardianship. There's a specific provision that you can petition the probate court with regard to this issue. They didn't do that
What
here.
provision is that?
It's in 510D, and then you see separate court rules with regard to this particular type of proceeding in MCR 5.784.
Yeah, I was trying to find, other than the guardianship, what the nursing home could do itself.
If you were representing the nursing home on November 15th, what would you have done?
I would have gone to the probate court and I would have filed a petition to say, we're not sure whether this revocation is valid. Please allow us to maintain the status quo and schedule an emergency hearing, and we will bring her to the court and allow the court to make that determination.
So bring me back to the period between November 8th and the 15th. What evidence supports the conclusion that the patient regained the capacity to participate in her medical treatment decisions on November 8th? I think that's about when you allege that happened, such that the suspension by operation kicks in.
So, Your Honor, I would point the court to the 7 bullet points that we've set forth on pages 13 and 14 of our brief. And there we point out that Ms. Hardy testified that it was her impression in talking with her grandmother that she had expressed this intention and that she seemed to be fully with it. Mr. Gallagher, the patient advocate himself, said that as of about 2 weeks before the hearing occurred on the 21st, so that'd be about November 7th, that she seemed to be with it again. She was talking normally, that the issues of delirium had ceased. And then you have, going further into that period, then the police officers visiting with her on the 13th, also saying she seems to be just fine, and the attorney visiting her on the 15th saying, boy, she seems to be just fine.
Well, I trust you. I trust that you know your facts better than I do, so I'm going to take your word for it, and I'll go look again. But I thought really that most of the statements were her saying she wanted to go home, and I'm trying to figure out how is that just is that just her desire, or does it say something more about her capacity to make medical decisions?
I think the affidavit of Ms. Hardy, the police report, and the testimony from Mr. Gallagher at least raise a factual question as to whether or not she had regained that ability as of sometime in early November, such that we're entitled to at least pursue this through discovery and potentially summary disposition and trial. Ultimately, at the end of the day, I think the issue here really boils down to the fact that a patient shouldn't be forced to have to go to court to establish that he or she is entitled to make her own medical decisions. That the bias that the legislature, or the policy decision the legislature has chosen here is in favor of those liberty interests, that if the institution wants to restrict them, the only way they can do that and avoid liability is to go to court and to get the judicial imprint to say, yes, they're authorized to do that. If they don't, we're entitled to pursue an action like this after the fact for false imprisonment and for the various other torts. Unless the court has any further questions, I'll cede the balance of my time.
Thank you very much. Case is submitted. Oh, I don't, you're out of time.